Good morning, everyone. I heartily welcome all on day two of 2 days national workshop on intellectual property rights for computer-related inventions. So today's our first session will be on patent search strategies for computer-related applications, and some tips
Hello everyone, this is
from.
Wasim from Edureka and I welcome you all to this session in which I am going to talk about data science projects.
Okay, sorry for inconvenience. Okay, so today's our first expert is Mr. Vijay Kumar Makyam. Sir, I heartily welcome you on behalf of Computer Science and Engineering Department of R&G Patel Institute of Technology. So this is the second session of Vijay sir. But in brief, I would like to introduce Mr. Vijay sir. So Mr. Vijay Kumar Makyam is a postgraduate in law with specialization in intellectual property rights and Master of Science in Information Technology. Sir has practiced intellectual property laws for 15 years. He had initially enrolled with the Karnataka Bar in year 2005 and got transferred to Telangana Bar. He had been counsel on record in various IPR cases before different high court in the country. He had been the guest faculty or a resource person at various well-known universities like National Institute of Micro, Small and Medium Enterprises Hyderabad, National Institute of Pharmaceutical Education and Research Hyderabad, University College of Law Osmania University, JNTU Hyderabad, JNTU Kakinada, Ministry of HRD, Ministry of MSME and various other universities for promotion of IPR. He is a registered patent and trademark agent for Indian Patent and Trademark Office and has filed and prosecuted patent and trademark applications and oppositions before the Controller of Patents and Trademark Registrar in India. He has also coordinated filing of patent and trademark application in some other countries including USA, Europe, Australia, Malaysia, Singapore, Sri Lanka, South Korea, South Africa, UAE and Japan. So I heartily welcome once again to Vijay sir and handing over session to Vijay sir to give us a brief idea about the patent search strategies for computer related applications. Thank you very much, sir.
Thank you. Good morning to one and all watching this presentation. You are welcome to second day of this session. Is my presentation live? Yeah.
Yes, sir. Yes, sir. Presentation is there.
So before I begin, as usual, I would like to give disclaimer that this is not meant for professional advice. It is only an academic purpose. Each case is fact specific, and there are some of the slides I have taken from other presentations, which is copyright exists with them, not with me. Thank you. And before I begin to talk about patent searches and all, I would like to say that patent law and innovations, once Abraham Lincoln has said, patent system adds fuel to the interest of the fire of genius. So that is the reason why patent system has been designed to make the genius exploded and more innovations come into the market is what the objective of patent system. If patent system derails the innovation, then it is not a good system. Patent system has to always fuel the interest of the fire of genius. Then innovation means doing something new that improves a product, process, or a service. Innovation is not just making a new product, but a new product which improves the existing product, process, or service. So patent law is to encourage inventions and innovations. The myth patent law confines the knowledge is not correct. Patent law is designed to properly disseminate the knowledge throughout the world. There are what are called patent classifications. In the coming slides, I'll explain what is patent classification and all. So through which this data is properly classified, properly maintained, and properly distributed. The objective of patent law is to promote innovation and encourage the development of domestic industries. Patent may be a powerful business tool allowing innovator to gain exclusivity over a new product or a process, to develop a strong market position and earn additional revenues through licensing. Patent protection is usually sought at the stage of R&D. Even before it goes into the market, patent has to be applied at the stage of R&D. The moment you conceive an idea and you are investing R&D, at that point itself you should file a patent application. in the technology life cycle. Governments, again here, government need to strike balance between protection of intellectual property and satisfying public needs. If public are not getting the technological product which is available, there is a medicine available, but there are patients who are lying on the deathbeds, is not appropriate. So if a medicine is available, that medicine should be made available to public at large at a reasonably affordable price. If just because government is granting a patent, he can't exorbitantly charge the price of that product. So government need to strike this balance of getting availability of product to public, at the same time giving some monopoly rights so that the new inventions can be encouraged, is what government need to do. Innovation, competitiveness, and intellectual property rights, be it patents, copyright, trademarks, are codependent entities which are also the cornerstone and foundation of global economy. If economy has to grow, that is the reason why we are giving importance to intellectual property rights in this era. If our economy required to be progressed, if our GDP required to be increased, what we need to do is we need to encourage more intellectual property, more innovations, more inventions, and those more inventions and innovations need to be protected properly, and monopoly rights need to be granted to the entities so that they can invest further money into the technology and further new products need to be developed and all. If you see this company Nokia, from Talkman till the latest mobile gadget, they have done multiple innovations in their company, and multiple inventions have come up in their company less than a period of 20 years. It is not one day or 2 days. It is less than a period of 20 years. They have come up with so much of innovation, and they were the market leader at once. Before Samsung and Apple has taken over the market, Nokia was market leader for mobile communication technology. Now, what is the importance of patent? I'll explain with a small invention that has been made by a UK inventor. Um, he has actually invented a ring can opener, like a ring pull can opener, so that from the can the liquid can be easily opened and drink by the users. So this inventor has been approached by the Coca-Cola company, and Coca-Cola company sought to purchase this product, which which the inventor said, I will not be interested in selling it. However, Coca-Cola offered huge amount to him, some 10 crores, 20 crore rupees, but inventor said, no, I don't want that much money. You just give me 1/10 of penny per can. And during the validity period of the patent, the inventor obtained 148,000 UK pounds a day on royalties, only from Coca-Cola company. He would have given a non-exclusive license, and he would have licensed to some other companies, Pepsi Cola or some other beer manufacturer, whoever it might be. He would have made some more money because he has not transferred the rights. The right belongs to him, and every time a can is made, 1/10 of money required to be paid to him, and thereby the Coca-Cola company itself has paid 148,000 UK pound every day till 20 years. Understand what is the amount he has made, how much technology, what is the R&D went into it, how much efforts he had kept. With the small invention, he made fortunes of money for himself. So that is the importance of patent. And non-respecting of IPR, what happened? There is another case study, Kodak versus Polaroid, wherein Kodak, we all know, a world famous company for manufacturing of camera related products. So Kodak is constantly developing products and releasing it in the market, and they have released one such product called instant camera. When they have released the instant camera in the market, Polaroid found that product to be infringing their patented instant camera. So Polaroid filed a case in the US court, and US court ordered Kodak to pay $935 billion because Kodak has not respected Polaroid's patent, and without taking permission of Polaroid, they have released the product. They have been ordered to pay $935 billion to Polaroid. By paying that, Polaroid amount, Kodak become bankrupt. Once a world famous company is now no more because they have not respected intellectual property. So whenever you are releasing a product in the market, you need to ensure that is not infringing rights existed in that particular product to some third parties. If some third parties have rights, you need to obtain licenses from them to operate in the markets. This is called freedom to operate analysis. Unless you do it, whenever you are releasing a new product, you need to do this freedom to operate analysis and then release the product. Now, what is the patent? Yesterday also we have seen this. Patent is a legal title granting its holder the right to prevent third parties from commercially making, using, selling, and offering for sale and importing of the patented invention without the authorization of the patentee. This has been provided under Section 48 of Indian Patent Act. This will be in return to the protection. The holder has to disclose the invention to public. It is quid pro quo. Yesterday also we have discussed that it is quid pro quo, that is give and take policy. You give information about your invention to the public, and public represented by central government will give you monopoly right for that particular product for preventing making, using, selling, and offering for sale and import by third parties. So it is a negative right. It is for a limited period of time, that is 20 years. It is geographic specific, not worldwide. Now, what is that? It is essential. Why it is essential for us to do a search, patent search, and get the patent information is there are several opportunities for us to exploit patent information. Patent is territorial, but disclosure is global. So, as I yesterday also said, if a person filed a patent application in USA, if a US citizen files a patent application in USA, that patent is not valid in India unless he comes to India and files an application. So if he doesn't file an application in India and he discloses the information in US, the US government makes it public through its website, and people in India can go through that information and use it without paying any royalty to that person. So that is the importance of patent system. The patent is territorial, but disclosure is global. Patents are limited in time. As I said, it is for only 20 years. After 20 years, you are free to use that information. Only first 20 years, the rights are given to the patentee. Otherwise, the information is free for society to use it. Anybody and everybody can use it without paying any royalty after 20 years. Only within 20 years, if you are using, you need to pay the royalty. Otherwise, you don't require to pay any royalty. No permission is needed. You are free to use that information. Then the scope of patent is limited by its claims. Though the disclosure has been made, what is claimed by the patentee, only that portion is protected to him. If he has disclosed and not claimed particularly in his claims, that portion is open for you to copy. So what is looked in when a patent specification is filed, not the entire specification is protected to him. What is written in the claims, that I'm showing it here in the pictorial representation. What is written in the claims, that itself is protected, not everything. The three pictorial images have kept there is, one is patent is territorial but disclosure is global. The other one is limited in time, that is 20 years, and the ownership of the patent is limited to the claims, not to the entire specification disclosed. So other elements, whatever disclosed in the patent while discussing about the technology, but not claimed, but pinpointly particularly claimed in the claims, is open for everyone to use it. Patents gives the owner a right to prevent others from carrying out their invention, manufacturing, and marketing, but not from learning from that invention. If you want to do further R&D, you can use that information and do further R&D and come up with a new product. So learning from it is not prevented. Like in copyrights, fair use, educational purpose is open for everyone. In patents also, under Indian Patent Act, Section 107A says that research purposes, it is research and learning purposes, it is okay. If you are selling the product in the market, within the 20 years, you need to take permission from the patentee. Otherwise, you don't require to take the permission from the patentee. Patents may or may not be granted and may or may not be remain valid and in force. So sometimes what happens, even though I filed a patent application, lack of prosecution, sometimes I don't file requests for examination and then automatically my patent will get abandoned. Or sometimes the examiner raises some objection. Examiner doesn't understand my technology properly and raises objections to the patent, saying that it is not patentable subject matter, it does not have novelty, it does not have inventive step, all the whatever objections he has taken, and then finally he refuses the patent. If he refuses the patent, you can use that information without paying any royalty. If patent is granted and it is valid, then you need to pay royalty. Sometimes what happens, patent need to be renewed every year in India. In US and other countries, the renewal fee timelines are different, but in India, every year you need to pay renewal fee. If you don't pay renewal fee, the patent there is 6 months grace period. After 6 months grace period, the patent will be ceased to exist. Once the patent is ceased to exist, he can't again revive it. So once the patent is seized, you are free to use the technology, that information, without paying any royalty. So that is the opportunity that you have as an entrepreneur, as a businessman. If you want to use this patent information, these are the areas where you need to look in and exploit the patented information. Now, I think yesterday I've already discussed with this. I'll not explain this slide, but patent process starts from idea conception, patent search, and then drafting, and then prosecution, objections from the patent office, reply, hearing and submissions, and grant of the patent, then renewals working, post-grant oppositions, and revocation. This is the entire process flow of the patent in India. So the requirements for grant of a patent is it should be eligible subject matter, novelty, utility, non-obviousness, specification. Yesterday also we have discussed. I have put the provision of law also here. Why patent search need to be conducted? To see if the prior art related to your invention exists or not. The first thing is to make sure that there is nothing, it is really your invention, it is not existing in the prior art. Your technological art, whatever you have made, that is your invention and it is not existing prior, is what you need to ascertain. That is the primary objective to do a patent search. Then helps to determine if you want to file an application or not. So once if it is existing in prior art, you will stop filing application, because the examiner also will come up with the same prior art and he'll refuse your patent. For getting a refusal, you don't require to file an application, right? So it will determine whether to file or not. Then helps to determine the appropriate claim scope when drafting claims. When you're drafting claims, whatever is existing, you will not claim in that your specification. When you are drafting claims, you say what is contributed by you and not what is already existing. So to determine all this, you need to conduct a search. Then, is the invention patentable? Does the invention infringe on any other patents? And is the invention is in public domain, which everyone has knowledge about? All these questions, to get answer, you need to do a search. Then, can I get a patent? To get clear answer of this, you need to do a patent search. Avoid needless expenditures. If it is already existing, reinventing the wheel, there is no point in doing research and then making application, processing it. All that is wasteful expenditure, you can avoid. Provide background information and operability or design. Whenever you're filing patent application, to make the technology understood by the examiner, you need to draft what is existing technology. So to draft what is existing technology, when you do a search, that information will be available to you. Learn commercial information. So it is also helping for financial analytics. How many patents have been filed in this area? How big is the market? That you'll get to know by doing a patent search. Then obtain proof of non-obviousness. In case there is no there is novelty, but there is no it is obvious to the technology, then to obtain proof of non-obviousness, you need to do a search. If there are less patents, there are not much number of patents filed in that particular technological domain, that means it is not that simple to do it. So to obtain non-obviousness, you need to do a search. Then to define invention around prior art. So what is your invention? What is prior art? To define that, you require to do a search. Then to know, the more you know, the faster you get the patent. So if you know the prior art very clearly, what is existing technology, what is your technology, then you will be easy it is easy for you. Even if the examiner comes up and says that this document is similar to you, since you already know about that document, you will say that this document I know, sir, my invention is different with this document in this way. You will explain that to the patent examiner. facilitated licensing or sales or evaluate potential value of the patent. All that happens by doing a search. Whether you are infringing some third-party patents, define what is the length and breadth of your patent will be done by doing a search. Easy to draft patent specification. When you do a search, then it will be easy for you to draft a patent specification. That's the reason you need to do a search. Then at what stage search need to be conducted? Developing IP strategy, filing, developing patent portfolio, utilization of patents such as licensing, mergers and acquisition. There are various stages you will do a search. So for what purpose this search is required? Research, design and development, manufacturing, commercialization, sales and marketing. Patent mapping and landscape search you'll do at the stage of research. At the stage of development, strategizing your IP or patent filing strategy analysis, you do a search. Then collection of prior art related information, also you do a search. Then manufacturing commercialization, you do a prior art search and a pre-filing search before getting into the market and before filing the application. Then invalidity search, a prior art search to cancel patents of others. That you will do when you are manufacturing and commercialization and sales and marketing. And clearance search, FTOs, freedom to operate search. Just before I explained about Kodak and Polaroid situation. When you are launching the product, you need to do a clearance search, freedom to operate search. And then when you're doing sales and marketing or mergers and acquisitions and all, you need to do patent evaluation search. So a patent analysis and landscaping, general patent prior art search, then invalidity search, all these are required at different stages. Various searches and focus areas. First, pre-filing search and patentability search. When you do before filing, materials to be reviewed, mainly all patent documents. Which countries you do worldwide, then what period, without any period of limitation, you do pre-filing search and patentability search. Then patent collection search in the initial stage of R&D, mainly patent data you will take. It is also worldwide without limitations. Normally within 20 years is what you collect. Then invalidity search to finding and receiving warning letters when you want to invalidate a particular patent, or when you received a warning letter, or when during the litigation when you want to invalidate a patent, you do this invalidation search. You need to review materials, both patent, non-patent literature worldwide. You need to do period in general published before cutoff date, that is from the date of filing prior to that. So the patent which you want to invalidate, from that date to the previous dates you will do it. Then FTO search, freedom to operate search, before launching a product into the market. All live patents, if there are dead patents, it is not hampering you to release the product. In only live patents, they you will be infringing. The patents which you are infringing, those patents you need to check up. Then countries where you are, it need not be worldwide, only countries where you intend to launch that product or service need to be searched. Period of search past 20 years. So the 20 years period only you will look in. Before 20 years, even if patent is granted, then it is 20-year term is over, you are free to launch it. So that is the reason why you do it for only 20 years. Then patent analysis or patent mapping or patent landscape search you do at the stage of R&D and strategy planning. Materials need to be reviewed, all patent documents worldwide without limitation, depending on technology characteristics, all that you will do it. So there are various 8 or 9 stages where you need to do a search. Conception and before R&D, before idea getting into your mind, before conceptualization of the idea, and to avoid reinventing the wheel and spend a lot of money in R&D, you will do a search there. And at R&D stage, when you are investing money into the R&D to ascertain if some breakthrough has already happened, and to take the research from that stage where it has ended last. So at R&D stage also you will do a search. Then prior art search for filing patent application to avoid legal costs in pursuing patent which lacks novelty. Then invalidity search for invalidating the patents granted by the patent office without paying due consideration to the prior. So you are digging it is kind of a peer review. You will dig out which is already existing. Patent office might have been not taken up. Then freedom to operate search for avoiding potential infringement situations where you are proposing to release a product in the market, and then you need to do like Kodak has not done. They end up in infringement litigation. So you need to do that to avoid such kind of a thing. Technology landscape search for discovering research ideas and solving problems, predicting hot areas in the research that can impact current products and those that are in the development stage. So you will also uncover the competitors by doing technology landscape search. But however, there is another type of search called competitor search, for which you want to monitor the competitor activities, what new products they are releasing, what are their future plans, or any new market players are coming in that particular area. Identifying patents owned licensed by different firms will be done by doing a competitor search. Litigation search, to invalidate, again, invalidation search and litigation search is one and same. To invalidate at a litigation stage, to uncover possible infringement or to escape from the possibility of liability. Then licensing in, when you're taking license in or when you're giving license out, to ensure you're giving a valid license or taking a valid license, you need to do a search of potential partners and all. And working around, when you want to enter into the market but you don't want to infringe, to work around a patent, you need to design around to develop a design around technology, you're doing a search. Then patent family, same invention filed in multiple countries. Sometimes it is continuation part and continuation applications, patent of additions will be filed for the same technology. So to uncover those things, you do patent family search. What are the advantages of doing a search? The inventor will be abreast with the field of technology, field of invention. So there are different school of thought people. One school of thought people say that by doing a search, your thought process will be influenced, you should not get involved. Some thought processor, some school of thought people say that while by doing a search, you'll get about all the information about the technology, and your knowledge will be developed, and from there you will continue further research. Will helps interacting with patent agents and others facilitating patent easy. If you have thorough knowledge about the technology, how many patents filed, what are the previous technologies, what is that you invented very thoroughly, you can easily talk to the patent agents and patent examiners and all for getting a patent easier. Reduces the time for filing and subsequent maturity of the patents. If you don't know, suppose an examiner comes up and throws a patent document to you and says that how different it is difficult for you. You need to first read that document, understand it, and then reply that will take longer time. If you know about it, you can it will reduce time and easily reply to it. Helps not to enter other territory and prevents infringement of third party rights. How do you find products on internet? Generally, when you want to do a search, how do you search general products and forget about patents? If you want to do a search for any books or any things on internet, you generally Google it or Yahoo search engines, you do a search, right? If you're searching for books, you will search by titles, author names, publisher names. You look into bestsellers in the set category of books and ISBN numbers, etc., etc. You will do it. Similarly, for patent search also, there are several techniques by which you need to do a search. So where to conduct a search for patents? I would say everywhere. It is not just one place. Wherever the patents are available, you need to do all those places. However, it is best to look in places most likely to contain information about particular technology. Your search need to be focused search. Way to conduct search, it need to be technical journals, patent databases maintained by patent offices around the world. Some private patent search companies will help you in doing that. For India, you have Indian patents and Indian published patent applications. Foreign patent documents like USPTO, EPO, and JPO maintains. Non-patent literature, any published document publicly available other than patents are called non-patent literature. Those can be searched on Google, Yahoo. Then there are trade publication and databases like ACM, IEEE, ChemNetBase, Mechanical Engineering NetBase, like that. Several technical journals, Springer and other journals are there. So all those journals you can do a search. The information, first of all, before even doing search, what is the information that is available to you within your organization? That is very important. Your in-house senior colleagues must be having some information about it. Your customers or users will be having some information. By doing a conference or exhibition, you'll get some information. From your competitors, you'll get an information. So government regulations or government rules will give some information. Products that you have used, products and services that you are using, that has information. Then anyways, the patent literature, the databases, and journals, patent journals will have some information. So you need to look around all this information. According to Thomson Reuters, 80% of all available technical information is published in patent and often nowhere else. So the major source is patent literature. So 80% of the data is available in patent literature. Only 20% you need to go in other databases or other areas, but 80% you will get it in the patent databases. Now, why patent databases? It is easy to get. There are various free and commercial databases available on internet. Thanks to internet, earlier in 1980s and 1970s, there is no internet. People used to do a manual search, so it used to take tedious process. But now, thanks to internet, we have databases available online. These databases are classified by what is called IPC, International Patent Classification. There are other domestic classifications such as combined patent classification, US patent classification, Indian patent classification. There are several things. So these patent classifications, they classify the technologies into different technological segments, and each technological segment is given a particular code, and that code is called International Patent Classification Code. And then there will be bibliographic data that is determined by WIPO INID code. For example, field date field is provided under 22. If you see a patent journal, there will be 22, 52, 18, like that. Some numbers will be there. So those numbers are called WIPO INID code for recognizing a particular field. So for example, inventor name will have a code. Like that, there are several things which have been codified for getting a bibliographic data. Then covering all technological areas in international patent classification, section A to section H, all the technologies have been kept in this section A to H. Described in detail about invention. A level, that a person having an ordinary skill in the art can easily practice the invention, especially according to the patent rules. So patent specifications are clearly described, unlike your technical journals where the data is not complete, or there may be incomplete information. But when you go in patent databases, the patent specification is so clearly written that an ordinary person skilled in that art can easily read that and manufacture that product. Much of the patent searching depends on number of factors to consider. How authoritative do you want the search to be? So you need to, before beginning the search, you need to ask these questions to yourself. How authoritative do you want the search to be? How up to date do you want the information to be? How much time do you want to spend on this search? Your comfort level with using computer and search systems. And then the invention, is it innovative technology or does it require such patent prior to 1975? What is the period of search you want to do? Your knowledge of US patent classification and recent changes to US patent classification or combined patent classification or international patent classification. You'll need to search both the keywords as well as classification system. Do you need to search just patents or also patent applications? Granted patents you need to search, or also patent applications. If it is FTO search, it is only granted patent applications, not pending applications, right? Then what are the different sources for the search? Worldwide search engines, free databases, uspto.gov, EP, espacenet.com, Japan Patent Office, jpo.go.jp, then IPO INPASS, Indian Patent Advanced Search System, then Google Patents, then commercially available patents like Total Patents, PatBase, Dialog, Questel Orbit, STN International, Derwent, Thomson Innovation, and all. If you want to get these databases, even without having the website, there are certain keywords that you can use it to get these databases. Like for Japanese Patent Office database, JPLAT-PAT, and US Patent Office, US Patent Database, US PAT FT, then eSpaceNet, eSpace Net, eSpace NT is what you need to use. Then Google Patents, simply type Google Patents, you will get that. In the search engine, if you type these keywords, you'll get. Then WIPO database, if you want to WIPO patent scope database, patent scope is a keyword, you need to use it. Then you can also engage private patent search firms to get this patent searches done. There are free databases and then commercial databases. Free databases, patent offices provide around the world, and there are certain corporates like Google Patents, Free Patents Online. So those people also provide it. Then corporate commercial databases like Questel Orbit, Microsoft Packbase, Thomson Innovation, LexisNexis Total Patents, Patent Square, Square Search. All these are the different databases, and their coverage area also has been provided in the right column. And what documents are available to be searched? Granted patents, published applications, foreign patent documents, non-patent literature. How do we start searching? We need to outline the invention. What is the invention? Once you understand the invention, then only you can do a search. If you don't understand the invention, don't attempt to do a search. You say that it is above my head, I can't do this search. You need to very clearly say that. You should not bluff to your clients or your friend who want to do a search to you. So you need to be thoroughly understanding the invention. Then think about most relevant information. What are the crux of that invention? How it works? What is its functionality? Then maybe you can write claims for your invention. What is that you have contributed? A claim is nothing but what is that you have contributed to the technology. Find all relevant patent classifications. What are the patent classifications, international patent classification numbers related to each claim? Search patents anticipating your invention as a whole. What are there any patents you need to do? Then search patents that would anticipate your invention. Then what you do is part 1, part 2, part 3. You do a search, and combination of part 1, part 2, part 3 is your invention. Whether it is whole or whether it is in parts already existing or not, you need to check. The objective of search is patent database will be there. You'll retrieve patents, transform into structured data, then extraction of structures, and then you do analysis. So patent database, pre-processing and processing, and then post-processing, what you will get is trend analysis, that is landscape report, technology forecasting, that is landscape report, strategic technology planning, then infringement analysis, novelty detection, technological road mapping, competitor analysis, identifying patent quality. All this you can be doing with the data that you dig out. The database, you mine it, get that information and process it and get these reports. So there are various parts. As I said, WIPO INDI code 54, 75, 73, 21, 22. Like this, these numbers are there, right? These are all called fields. So title is provided under 54. General description of invention, not the product name. The inventor names, assignee owner of the patent, references cited, patent number, unique identifying code, filing date, application was filed, often the priority, this is also called priority date, classification codes. These are the classification, international classification code, and then US classification codes. So all classification codes have been provided here. Then there are various types of patent searching. There, like you have patent number, you'll check by number, that is called number searching. Then assigner name or inventor name or applicant name or country of applicant, inventor country or inventor state, inventor city or applicant city, the name searching. Then subject searching, the subject keyword searching you do. Then the legal status searching. Legal status is whether live or dead. All dead patents are all live patents. Then IPC classification is actually international patent classification was established by Strasbourg Agreement in 1971, and it is continuously revised by International Patent Classification Committee of Experts. Then you can also do date search, search the databases with specific dates. Then search terms, keywords, numbers, and then patents of interest. Then patent classes, like IPC classification, there is a main class and subclass. All those things you can do a search. Number searching, patent number or patent application number, country of issue, and then common format country code followed by 7 or 8-digit number. Like GB is Great Britain, WO is WIPO patent, D is German patent. Like that, these patent numbers you can do a search. Then number searching, document kind code. There is what is called number followed by a letter, A, B, T, etc. A means first stage publication, B is granted patent, R is reissued patent. Like that, there are kind codes to the number. First you get the country code, then the number, then after that the kind code will be provided. In the below example have given application search report. A1 is application search report. A2 is only application, only that application is there. A3 is application, only search report is there. A1 is both application and search report. A2 is only application. A3 is only search report. A4 is search report by the EPO added to search report done by the PCT. So WIPO has given several other codings, A1 to A4. So A1 is application. Like this, these kind codes have been designed. The name searching, inventor names, company and organization name, assignee city, assignee country. Then subject searching, you can search in the title, keywords in the title, keywords in the abstract, keywords in the claims. Then classification codes, international patent classification, other classifications like European patent classification, combined patent classification, US patent classification, British patent classification, Indian patent classification. There are several classification codes. What you need to do is list out all the keywords relevant for your invention. Also the synonyms for each keyword. However, searching by keyword alone has pitfalls, since different words can use to describe the same thing, and the same word can be used to describe different things. So keyword search alone is not perfect. So you need to also do, in addition to keyword search, classification search also. So when you are doing keyword search, there is what is called, I think all of you are computer related people, you must be knowing this SQL, structured query language. Your keyword and then logical operators and or not, then patent classification, applicant assignee, and other data like date, status. You can make a structured query language request and retrieve the data. So it is database mining. Essentially, patent search is nothing but mining of the patent database. So how do you your database systems like DBMSS, database management systems, how they work? Similar things. Since it is a database, you need to do a search in a structured query language. What is the keyword and what is the classification number and applicant and other data you give, you get the results. Example here, ethylene vinyl acetylate copolymer that need to be searched. We are used in silicon solar cells as sealing material. So for that, we need to do a search. So technical features is a solar cell. Solar cell can also be called silicon cell. Sealing material and EVA are the things that have been there. So how do you do a search? You need to write all these keywords, do a search, and then there is what is called classification search. The arrangement of patent literature in group according to its technical feature is called patent classification. Almost every country has its own classification, and there is an agreement called Stansberg Agreement on international patent classification too. Classification of inventions can be derived as follows: by reading. How do you get the classification? By reading manually the patent classification, listing, conclude, and relevant classes. Based on the search results, if you search keywords, you get some results. In that key results, there will be classification numbers. If it is relevant classification number, you can do that. So there are two ways to identify classification. One is by reading the entire manual. Second one is by doing a keyword search and understand the relevant classification. So classification search brings the related prior art to the group to be grouped together and helps the target of the search. So keyword search will get you unnecessary patents. Thousands of patents will come in results. When you combine keyword search with classification search, you get the target results. So what we need to do is, preliminarily, you need to do a simple keyword search, then check international patent classification, and then do a classification and keyword search together to get the better results. So these are the classifications, international patent classification. IPC divides patentable technology into 8 key areas. Section A is human necessity, B is performing operations and transporting, C is chemistry metrology, D is textiles and papers, E is fixed constructions, F is mechanical engineering, lighting, heating and weapons, G is physics, H is electricity. So all the major technologies are classified into these A to H categories. And there is, if something is missing, that goes under Y, general tagging of new technological developments, general tagging of cross-sectional technologies spanning over several sections of the IPC, technical subjects covered by former United States patent classification, cross-reference art collections. So anything that is not fitting this in 8, the 9th section is section Y. So these are the 8 sections. This can be available on WIPO website, wipo.int. You need to search for IPC, International Patent Classification. Then you will get this. You can simply type the class number, you will get it, or you can do a search for the keyword of particular technology. That classification, you will get it. It is subclasses. This is the main classes, and then the subclasses. A1 is agriculture, A21 is foodstuff, baking and edible. Like that, you have different classification. See, A01 is human necessity, agriculture, forestry. Like that, there are different classifications. And in between, if there are cross links of a different classification, like B60N, E06C, or different furniture, that is human necessity under A47, but it also falls under B60N and E06C. So that is how it has been referred. Now, if you see an example of international patent classification related to electrical vehicle, so what are the different classification? EV system itself, B60L1118, like that, battery charger, power electronics. There are several different equipment, and each equipment has a different classification number. So you need to identify the classification number to do an appropriate search. Structure of patent classification. So main class, subclass, main group, subgroup. So you need to identify B is main section, B25 is main class, B25J is subclass, B25J13 is main group, B25J/202 is subgroup, B25J13025 is the classification number. So like that, you need to split the classification code into different segments. Now the same thing I have shown it here with another example. Diesel particulate filler. I want to do a classification. I want to identify the classification number. So those highlighted in red are the closer classification numbers. So by doing a combination of classification and keyword search would result in accuracy of the results. A classification search provides all patents that class, and thereafter keyword search and results of the classification search would provide patent close to the invention. So first you do a classification search, you get 1,000 patents, and then you do a keyword search. In that, you will get 10-20 patents. Apart from patent literature, the search required to be performed in technical journals and general web literature for better results. So there are different patents of search queries. Patent 1, only keywords combination, easy to understand, but might hit many noise document, irrelevant documents will come, like diesel and particulate or soot and filter and PT. Like that, if you give a search query, you get several things. Wherever diesel is there, you get that document. So it is a lot of documents you will get, a lot of document review required to be done. So when you do a classification, only classifications combination, goods locate highly relevant documents, but possible not to locate important documents. Only when you do only classification search, you might get highly relevant, but some important documents you might miss. So combination of between keywords and classification, most reasonable search query to locate the relevant documents. So you need to use the IPC classification as well as keywords to get the results. So there are 3 patents. Of 3 patents, third patent is more relevant, more hitting, more appropriate is what I'm saying. There are various databases, as I quoted. We have free databases, paid databases. Now, before doing a search, you need to do a search strategy. You need to brainstorm keywords to describe your invention. Think appropriate synonyms because there are more foreign languages involved. If you do search in Russia, what this particular we call it vehicle, they call it something else. So what are the synonyms you need to use it? So different. See, though patent grant is territorial, the search will be done throughout the world. If something existing in some part of the world, Russia, Germany, or Australia, some invention is already there, you won't get a patent. Patent will be given only to things which are novel, which is unique, which are not existing any part of the world. So your search need to be done throughout the world. So you need to do a brainstorm of keywords and get some keywords. Use keywords to search for similar match of your invention in Google Patents. Google Patents is free, so you can use Google Patents to get keyword search. Note the class and subclass of similar invention either in United States patent classification or combined patent classification or both or international patent classification. Then use class and subclass to search patents and patent applications at US Patent website, eSpaceNet website. Trace related patents through references and then read them, understand whether it is similar to your invention or not. Then FTO searches, freedom to operate searches, identify the country where you intend to launch your product or use your invention. Identify the search engine, then know the law, doctrine, and case laws of that country, whether doctrine of equivalence is applicable or not, or any other rate. And then collate relevant patent opinion. So when you're doing this FTO analysis, you need to take patent number, priority date, expiry date, dependence of the independent claims, whether they that need to be the analysis what you need to do. If no infringement, go ahead with the launch of the product in the country. Search invalidate. If there are some relevant patents are there, then search invalidation grounds for hindering the patents. Validity search like file revocation of the patent application. Is it possible for you to file a revocation, cancellation of that patent if there are patent existing, if there is prior art existing? In case patent application, search the prior art to analyze whether you would file oppositions or not. In case it is infringing, then design around how without touching the claims what he has filed, design around that. Or then if that is not possible, take purchase patent or take in licensing or cross licensing or compulsory licensing, whatever is available to you that you need to if that is not possible, if it is infringing and the design around is not possible, purchase is not possible, license, forget about the product. For time being, wait. Maximum positive unit specification to understand the scope of the element. Now read your invention over the claims wherein you broaden the claim to its maximum scope. So when you are reading claim, you need to broaden the claim scope to the maximum and then compare your invention with the claim. If it is matching, then it is infringement, otherwise it is not infringement. One must read prosecution history of the patent as well to analyze the infringement. When you are analyzing infringement, you need to read the prosecution history also. What patent examiner cited documents, what replies applicant has given, how patent has been granted. Once it is granted, when you read prosecution history, whatever is excluded in prosecution is a stop to claim again in the infringement action. Is it advised to do a prior art search? There are two, as I said, there are two kinds of people. Some people say that it influences your thought process. Some people say that it is required to do a prior art search to make appropriate claims. This is US patent website. There are any database, there are three types of searches. You all know because you're all computer related people. There is what is called quick search, advanced search, and patent number application search. There are two different databases, issued patents and published patents. You can type the keyword and use a logical operator. And then there are truncations, like in this example, term 2, tennis racket, and tennis racket in the title, and ball I have given a dollar symbol. Dollar symbol means ball or balls or any other thing which starts with ball, and then I'm asking that to be searched in the abstract. There can be nested balloons like television or cathode and tube. So you can use brackets to make nested relation. To have exact phrase searching, if you give just tennis racket, you might get results of tennis or racket. But if you want just tennis racket together, then you need to use in quotes. Then truncation, as I said, dollar symbol is used, electronics, electrical, anything that comes with ELEC, that will come if you use dollar symbol. Then field search, you can use patent number, classification, title, abstract. So you just require to give this short form of this fields, and then that number, CCL, classification number 43 by 2 is what I'm giving example. Enables retrieval of patents based on the selected field. There are different fields, like here PN means patent number, ISD is issue date, TTL is title, like that. In example I have given TTL, that is title, tennis racket, and racket or racket. So that is what I have given a query title. ISD is issue date from 1st August 2002, and motorcycle, and then IN is inventor name, Newmark Julie. So like that, we can do a query search, advanced search. Then classification search, like I said, patents have been classified. US patent classification provides storage and retrieval of every US patent document that patent examiner need to review when examining patent applications. So the hierarchy is like this. Technology is divided into 3 major disciplines: chemical, electrical, and mechanical. And then each discipline is further divided into sub-technologies. Electrical is again communications, computers, physics, optics, system components, like that. Then again, each sub technology is divided into classes. Electrical, main technology, and then communications. Then in communications, class 379 is telephony, 382 is image analysis, 455 is telecommunications, 340 is television. So you can read the classification number, broke into smallest division, and then do a search for that classification. The advantages of the doing this is the title and definition of each class and subclass are text searchable. Benefits of organized classification system: you will get only relevant patents. Manual of classifications available on the website. There is a guide for manual of classifications, and you can go through the classifications. So this is the classification manual of classification, where it is available on US website. You can just type the classification number, you will get the result, or you can search, you can give the keyword. A is getting the classification number, B is using a keyword, you can do a search. Then you can read the entire classification also to get the search results. The entire classification, while reading, you will get the class definition. There is P written beside that classification manual. When you click on the P, you get all patents related to that class. There is also A, blue color A, that gives pending applications. So you can either click P for getting patents, or A for getting applications in that area. See here in this example, class 2 apparels, there is A means pending applications. Then bottom you are seeing P is granted patents. So there are logical operators also, as I said, and, or, not. You can use, you're all computer experts, I don't require to explain how this logical operators works in the databases. Or you can use truncations also. So first, after getting the results, what you need to do is first scan the titles of the patent, note the classes and subclasses of pertinent patent. Then the classes you need to understand, and then you need to do whether it is relevant class to your invention or not. You need to check, and then constantly. It is a constantly you need to do this manual of classification search, and then get the classes number, and then read the combination of the following fields. use synonyms, use truncation, then read manual of classification, constantly evaluate results. Text searching is iterative process, like you need to do multiple search. Start with big net, like big query, then refine your search results to step by step. Find the relevant, see if, for example, this inkjet printer, if you want to do a search by doing an exercise. So first we need to do where this inkjet printer falls into, which relevant international patent classification. What are the keywords that we need to use? Is it printer, printing device, inkjet, photocopier, Xerox, printing machine, printing apparatus, duplicator, output device, portable printer? So these are all synonyms that you need to make out the keywords. Then finding the keywords and synonyms based on general concept or broader concept, and then specific concept. Then in other words, rewording of that, what are the essential elements in it, all those things you need to look in. For example, this solar cell, finding synonym: solar cell, photovoltaics, PV cell, solar battery, electrode, sulfide, cardamom, lead layers, photodetectors, extensions, photoelectric chemicals, micromorphs, silicon. All these are the different names for the same thing, right? So another example for chemical related inventions, step one is to identify the chemical structure, then find out IPC classification, then chemical structure sequence search you need to do, then assignee and inventor search, then non-patent literature search to get the search report. Then when you're classifying, how in the classification search, when you're searching for solar cell, you need to search all classification numbers, 1, 2, 3. You need to put highly relevant or partly relevant. All 1, 2, 3 classification numbers you need to take, and then you need to do a search. Earlier, I would say Stone Age, that is before computer era, a manual index search was performed in public search room at USPTO or any other patent offices. Satellite search rooms at patent and trademark depository laboratories. Each city will have a small PTDLs, patent depository laboratories. Or in India, there are 5 offices, patent offices: Bombay, Delhi, Chennai, Calcutta, and Ahmedabad. There, this patent journal used to be sent. That journal used to be kept there. I personally, in 2005, I went to the Chennai patent office. When the database is not online, I went through all the patent journal pages. I used to do, I did a search for asthma related drug for 30 days. For day 1 to day 30, every day I used to go to patent office, take out the patent journals from 1970 till date. All the journals I need to use to look in, wherever the word asthma comes up, I need to take that photostat and keep it with my database. So that's how the manual search has been done. Patents were classified into relevant classification titles and stored in shoebox. Since then, the patent classification codes came into existence. Actually, later on, microfilms and then CD-ROMs were used to store patent data. With computer era, computerization, the patent search was well fixed with syntactical or command-based search using different computer patent databases. So now we are using patent databases. Now the era is patent search user-friendly with huge patent volume searches searchable online at a greater speed. Artificial intelligence could search patent examiners as part of prior art search process. The proof of concept allowed retrieve most relevant documents, rank them, visualize their content. So all that is possible through artificial intelligence. Artificial intelligence is less effective in formulating search queries, but can reduce the time and cost of process of sifting through large number, or like going through large number of patents. Humanly, it is very difficult task, right? The technology, as the technology progresses, the number of patents also importance of human-centered decisions and performance support in prior art searching is essential. Novelty, proof of overlap with prior art and novel elements. Then visualization. Once visualizes computer protection in a technology of interest that visualizes, improves the quality of patents. You can based on If less quality of patents are there, you can abandon or renew out licensed can be based on the searches. Identify key patents in the portfolio. Automation in invalidity searching. Use of sophisticated tool in systematic dissemination of information. Automation in inventor counseling. Automation in ideation. All this is possible. AI in patent searches, the significant growth in volume of patent and non-patent literature, which is present in multiple formats, multiple languages, and multiple sources, to be searched and analyzed by patent attorneys to identify the most relevant information, has made the process of carrying this out manually overwhelming and laborious. It is humanly impossible today to do the search manually. AI provides benefits to patent searching in terms of time saved, cost saved, while providing accuracy and assuring the quality of the search. Instead of prior art research taking between 2 or 4 days, AI can do this legwork in just a couple of hours, thus giving the searcher a head start when it comes to manual analysis. Schematic-based algorithms can help a searcher to find most relevant document, regardless the terminology or language used, as they focus on digging out the information and performing document retrieval by identifying the meaning in accordance to appropriate text. AI-based patent search tools are provided the neural network analysis and schematic vectors like machine learning, natural language processing, automation and robotics, and machine vision, incorporating language model and a literary are object a fewer false positives. Like, you will get only accurate documents, not irrelevant data. Complete and deep data of market insights will be provided. Provides a more specific domain and nuanced understanding of the words that user are typing in along with the user query and text. So computer also understands what is that you are searching for. Advantages of automation of patent search process. Searching methods and accuracy, reduces manual work, saves plenty of time required and minimizes the cost. Conclusion on AI uses AI and giving, for example, the top 50 patent to analyze
Yeah, dear participants, due to internet connectivity, we are facing a problem. Just wait for a moment. Yes,
I'm
sir.
extremely sorry. When I don't know whether it is last slide or when did I
No,
disconnect
sir.
it?
We just 1 minute before, so we have completed that AI and ML related search queries.
Okay.
Yeah,
So,
just 1 minute before you got disconnected, sir.
it is conclusion of AI usage has been done.
Yeah, it has been done.
Okay, so there is a link which provides WIPO artificial intelligence on patent search, and then conclusion. I said that we need to have the knowledge about patent information and databases, and then the keyword and classification queries, and then how to automate this. If you have any questions, I'm open for answering them.
Yes, sir. First of all, thank you very much for giving us a brief and in-depth information regarding the importance of pattern search and analysis and how we can do it. Actually, some things are not aware to us also, and we got came to know from your presentation. So, sir, a few things I have received that for filing a patent, do we need to consider journals or article, or this search analysis is required only from patent database?
I would recommend both. You need to do search
Both, right?
in a patent database as well as journals and articles.
So, will it
See,
impact?
anything that is in public domain becomes negates your novelty.
Huh,
So whatever is
right.
in public, like for example, what happened with turmeric, antibacterial property of turmeric in
Hmm.
US, the US patent examiner searched in only patent database and they granted patent. Then we said that this knowledge is very much available in
Hmm.
public. Then they asked for the proof of the document. Then we wrote to get the patent grant.
Right, right.
It might be patent
Uh,
database or non-patent database. Yeah.
right, right, sir. Right. So, is it okay to do PSAR using free database, or do we need to consider paid database also? What you advise, sir?
Yes, that should be the start.
Hmm.
So
Sir, actually, your voice is lagging.
if you get exact internet,
Hello.
is it clear now? Is it clear now?
Yes, sir. Now it is clear, sir. Right.
Very good. What I was saying is, um, when you are do when you get a idea, when you conceive an idea, you need to do a search free databases. If you get a similar thing, you don't require to go for paid databases or a patent attorney. The moment
Right.
you feel that it is not existing, you can go and search for it. You can go and you can engage paid database and good. If you can't differentiate, you can stop the. If you cover the invention within the free.
Right. Right. So, thank you very much, sir, for your valuable time for providing us a knowledge regarding IPR for computer-related inventions. During last 2 days on behalf of CSE RNG PIT, on behalf of head of department and the principal of RNG PIT, I heartily thank you for your valuable input and your time. Thank you, sir. Thank you very much.